13, 14, and 27 of cyanamide.
13, 14, and 25.
27. 4 to 7, 13, 14, and 27. The second case is Shri Sitaram Sugar, Constitution Bench, paragraph, that's 1990, volume 3, SCC 223, para 31, 35, and 37.
Please tell the paragraphs again, Mr. Secretary.
31, para 31, 35, and 37. Oh, ठीक है. The third is 2002, volume 2, SCC, page 7, State of Punjab versus Tehal Singh, that's paragraph 6. The first two are in the context of price control orders issued under Essential Commodities Act, Section 3.
Yeah.
And the third one is in the context of a notification for establishment of Gram Sabha areas under the Panchayat and Zilla Parishad Act.
Delimitation.
Not delimitation, but establishment of Gram Sabha, not in the context of election. And this cyanamide has been followed, the Constitution Bench has approved. So Lordship has just one paragraph of cyanamide. I will not read the other ones. The third observation we wish to make is price fixation is more in the nature of legislative activity than any other. It is true that with the proliferation of delegated legislation, there is a tendency for the line between legislation and administration to vanish into an illusion. Administrative quasi-judicial decisions tend to merge in legislative activity, and conversely, legislative activity tends to fade into and present an appearance of an administrative or quasi-judicial activity. Any attempt to draw a distinct line between the legislative and administrative function is difficult in theory and impossible in practice. Though difficult, it is necessary. I am relying on this portion, that the line must sometimes be drawn as different legal rights and consequences may issue. The distinction between the two has usually been expressed as one between the general and the particular. A legislative act is the creation and promulgation of a general rule of conduct without reference to particular cases. An administrative act is the making an issue of a specific direction or the application of general rule to a particular case in accordance with the requirements of policy. Legislation is the process of formulating a general rule of conduct without reference to particular cases and usually operating in future. Administration is the process of performing particular acts, of issuing particular orders or making decisions which apply general rules to particular cases. It has also been said rule making is normally directed towards the formulation of requirements having a general application to all members of a broadly identifiable class. So that is sufficient knowledge for my purposes. So relying on these three judgments, in support of my submission that the SIR order is in legislative character, why I am doing so is, my Lord, becomes significant when the Lordship will examine, my Lord, when I come to section 21(3), which says recording of reasons. So the recording of reasons, not when an administrative order is issued deciding having a civil consequence, or an administrative order, which is or a quasi-judicial order or a judicatory order. So the reasons in a judgment are of a different kind. But if the order is of a legislative character, it would be somewhat something akin to. I'm not trying at all to equate the authority of the Election Commission with Parliament. No. Parliament is a different organ, supreme organ in legislation making under 245, 246. I do not have that power. I don't claim that power. But nevertheless, as Mohinder Singh Gill says, that 324 is plenary. Now, if an SIR is issued under 324, read with section 21(3) or other enabling powers, then that is not legislative in character, and the reasons will be somewhat akin to that. What I have to indicate under 21(3) is why am I holding this special revision? It has nothing to do, there's no list involved when I issue an SIR. The normal procedure of summary, etc., is prescribed. The rules are there. All of them contemplate a deviation. So why am I deviating? So the reason has to have a nexus with that and that alone. And that can't be something akin to adjudication or an administrative order which decides somebody's rights or something. So it's for that purpose, limited purpose, not that this I have. The third judgment which was relied upon by the petitioners was A.C. Jose versus Sivan Pillai. That is 1984 2 SCC 656. Now, this was a case, my lord, where my lords, the rules prescribed that the voting should be done by ballot papers. But it was decided by the Election Commission that we will experiment before introducing this EVMs throughout all constituencies all over the country. We will first experiment in few constituencies. That was challenged. The rule had not been amended. The Election Commission had gone to the Government of India for permission. The Government of India had refused. Yet, not that order had been issued for experimentation. It is in this context that this judgment was rendered. In paragraph 5, the arguments have been noted, lords, and right, some judgments noted in paragraph 11. It's paragraph 20, kindly come to para 20. We fully endorse and follow the above observations of the Constitution Bench, which lay down the correct law on the subject, and we have nothing further to add to the approach made by this court in the case referred to above. On the other hand, our view, Article 324 to 329 have to be construed harmoniously, flows as a logical corollary from the ratio in Punuswami's case. The pointed observations extracted above really amount to a Bible of the election law as culled out from an interpretation of the provisions of 324 to 329 of the Constitution, and we are referred to with approval even in Mohinder Singh Gill. During the last 3 decades, this case has neither been distinguished nor dissented from and still holds the field, and with due respect, very rightly. No other case has ever been made such a dynamic and clear approach to the problem, and perhaps due to the fact that no such decision arose before, the Commission has always been following the provisions of the Act and the rules and had never attempted to arrogate to itself powers which were not meant to belong to it. Indeed, if we were to accept the contention of the respondents, it would convert the Commission into an absolute despot in the field of elections so as to give directions regarding the mode and manner of elections, bypassing the provisions of Act and rules purported to exercise powers under cover of 324. If the Commission is armed with such unlimited arbitrary powers, and if it ever happens that this person manning the Commission shares or is wedded to a particular ideology, he could, by giving odd directions, cause a political havoc or bring about constitutional crisis, setting at naught the integrity and independence of the electoral process, so important and indispensable. Further, such an absolute and uncanalized power given to Commission without providing any guidelines would itself destroy the basic structure of the rule of law. It is manifest that such a disastrous consequence could never have been contemplated by the Constitution makers, For such an interpretation as suggested by the counsel for the respondent would be far from attaining the goal or purity and sanctity of the electoral process. Hence, we must construe Article 324 to 329 as an integral part of the same scheme, collaborating rather than colliding with one another. Kindly mark this, Lord. Even I submitted, Lord, that they are in a symbiotic relationship. Moreover, a perusal of Article 324, 329 would reveal that the legislative powers in respect of matters relating to Parliament or state legislatures vest in Parliament and in no other body. Commission would come into picture only if no provision has been made by Parliament in regard to the elections to Parliament or state legislatures. Furthermore, the power under Article 324 relating to superintendent's direction and control was actually vesting of merely all the executive powers and not the legislative. Kindly mark this sentence, Rose. This is running contrary to Vinder Singh Gill, which said that all three powers, including legislative, are there. This and their lordships have not noticed one of the symbols cases which I have cited, Sadiq Ali and all in. In other words, the legislative power of Parliament or the legislature, of course, I don't legislate in the same sense as the Parliament. We don't do that. And probably it is that which their lordships have in mind when they say that not the legislative powers. In other words, the legislative power of Parliament or of legislature of state being made subject to 324 only means that no law made by Parliament under 327 or by state legislature under 328 can take away or deprive the Commission of the executive power in regard to matters entrusted to it with superintendent's direction and control of election. This again is not accurate, Lord, and militates with the other judgments. Now, please have paragraph 26, the particular provision which was an issue. Manner of voting at elections, section 59, that's quoted. At every election where a poll is taken, votes shall be taken by ballot in such manner as be prescribed, and no votes shall be received by proxy. So a specific, exhaustive, the rule is of an exhaustive character, that you will have a poll based on ballot papers. And since there was a deviation, and that is what emphasized in 27, it is obvious that section 59 uses the words ballot in such manner as may be prescribed, and prescribed means by rules, which means prescribed by rules made under the Act. A reference to section 61 would show that Parliament intended use of ballot paper only for casting of votes. This takes us to Rule 49, the relevant part of which is extracted. Notwithstanding anything contained in preceding provisions of this part, the Election Commission may, by notification published in the Gazette at least 15 days before the date or the first of the dates the poll appointed for an election, direct the method of voting by ballot shall be followed. So in para 29, the court concludes that on a proper and detailed analysis of these rules, it is clear that by framing the rules completely excluded the mechanical process. So if your lordship comes to the conclusion that this SIR order is this nature of order is completely excluded, and I'm emphasizing completely excluded. If there is no complete exclusion, no exhaustive enumeration, then, my lord, 324, etc. is not ousted. And JOS is of no assistance to the petitioner's submission. It has no bearing to the nature of exercise which we are conducting. If your lordship has page 12 of my written submission, I will not read these cases. These are all on the symbols order. 4 cases have been cited with paragraphs have been mentioned. All of which show, my lord, that 324 includes such a power, and it was upheld because the rules permitted, the symbols rules, Rule 5 and 10 of the conduct rules, they contemplated that Election Commission will prescribe. Now, Anup Barnawal, Lords, I am not going into detail because I am not contesting the formulation that the right of an elector to be registered and by necessary implication to vote is a constitutional right. But it is dependent upon the fulfillment of the three conditions. And this case, in any way, my Lord, was concerned with how the election commissioner the background of that in which the issues arose there and the horse, the rules, etc., which were under consideration. And those cases, again, my Lord, I need not read, that's well settled, my Lord, in this. I have mentioned the judgments there. Paragraph 6. Part 3, my Lord. Section 3. This page, your Lord. Now, at page 17, I have specifically dealt with probative value. If your Lordship grants me the indulgence, my Lord, the heading may be corrected slightly by saying adequate probative value, because that's the expression which Lal Babu's case. I have already made my submission, my Lord, that why, my Lord, our SIR provides adequate probative value. And in particular, para 15 may be noted where I have mentioned, my Lord, that the earlier previous SIRs were conducted, and that was the context in which Lal Babu was rendered. Now, my Lords, if I may come to the statutory provisions, the next part of the submission. Kindly have the Representation of People Act. And backward. Kindly have the Representation of People Act.
1950.
1950, I'm sorry. Yes.
Yes.
So now my endeavor is to show that Election Commission is not, the doors of revision in a special manner are not foreclosed, rather expressly permitted. Kindly have section 15. For every constituency, there shall be an electoral roll which shall be prepared in accordance with the provisions of this Act under the superintendent's direction and control of the Election Commission. So 324 is expressly preserved by section 15. Would you like to tell? Now, this provision has been just like this from the very beginning, 1952, when it was made. Now, then have section 21. Electoral roll for each constituency shall be prepared in the prescribed manner by reference to the qualifying date and shall come into force immediately upon its final publication in accordance with the rules made under this Act. Now, this is the original provision. Now, kindly have two. The said electoral roll shall, unless otherwise directed by the Election Commission for reasons to be recorded in writing, be revised in the prescribed manner by reference to the qualifying date. If I may request the Lordships to pause here. Even subsection 2 says, unless otherwise directed by the Election Commission. I am emphasizing this expression. Kindly mark this, Lord. Yes, right. And this revision is the regarding the electoral roll made under subsection 1.
So there is a power vested in the Election Commission, even over and above what the legislature has infused in 21(2).
Yes, 21(2), 21(3), both are provisions of Parliament, and the Parliament envisages that the Election Commission can otherwise prescribe. And this otherwise prescribed is in the context of revision of the roll prepared under subsection 1. It says the said electoral roll shall, unless otherwise directed by the Election Commission, for reasons to be recorded in writing, be revised in the prescribed manner by reference to qualifying dates. So if I don't revise it, then the rules operate. But if I revise it, if I direct otherwise, then that change, the rules will operate subject to the change.
And power overriding the rules or whatever that can be enacted by the legislature.
That's it. The rules will are made by central government under this in consultation with the commission. Circumstances prevalent in the state. "21" is a parliamentary dispensation, nothing to do with central government. Central government will come in when the rules are made. And it says before each general election to the House of People, 2 before each by-election House of People or the Legislative Assembly, 2 before each by-election. So the revision must take place before each state assembly election. Ordinarily, it will be in accordance with rules, but the Election Commission of India can, taking note of the circumstances prevalent, direct otherwise. Now, B further makes it clear that this has nothing to do with the time. It has to do with the content of that is the rules according to which revision election is to be held, roll is to be prepared. B says, shall be revised in any year in the prescribed manner by reference to the qualifying date, if such revision has been directed. So if it is being held otherwise before the elections, then it is to be done in the prescribed manner. The discretion is not there. Provided that if the electoral roll is not revised, the validity of the old electoral roll continues. That's not affected. Now, 3. Notwithstanding anything contained in subsection 2, the Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency or part of a constituency. Here again, subsection 3 says that the Election Commission may, for reasons to be recorded, direct a special revision in such manner as it may think fit. This expression. The net result of the expression, unless otherwise directed in 2A, and as it may think fit in 3, so the Parliament has not closed the door for Election Commission, but rather preserved its powers and functions under Article 324 for the purposes of providing a methodology of preparing roll, which is otherwise than the rules, otherwise than as prescribed in the rules. So the position, my lord, is clear that this case is unlike Joe's, where the rule said you will do it by ballot paper, and this court interpreted to mean ballot paper alone. Therefore, Election Commission could not deviate. But here our section 21(2) and 3 both read together expressly preserve the power of the Election Commission of India to deviate. So 324 is not shut out, not foreclosed.
Parliament has notified, or the legislature has notified a set of rules. Say, for example, for the revision of electoral rules, 21(2) enables you to go even beyond those rules, because those rules are subject to your power. You have an overriding power over those rules. Then, assuming that in exercise of that overriding power, you notify something which is over and above those statutory rules, then subsection 3 absolve you even to follow that your own notified criteria, rules or regulations.
2 is before every election. Now, for example, in many states, Lord, there is no election happening. It's only in 5 states where there are elections in this particular year. So where there is no election in UP 2027, then 21(3) comes in. At any time, we can direct special revision. Both are akin, identical, with same kind of power. Of course, we have to be fair, just and reasonable. That mandate of Article 14, fair, just and reasonable and transparent.
Are you saying that subsection 2 of subsection 21 and subsection 3 of section 21 have the same nature of inquiry or preparation of
The
those?
same width.
Is it so?
That's my humble submission was. Because unless otherwise directed, revise in the prescribed. Hmm.
21 is completely liberated. There is no prescribed manner. Prescribed manner का जिक्र ही नहीं है 21 यहाँ prescribed manner reason से बहुत कम हो जाएगा start में ही नहीं है जब यहाँ start is understanding into do में prescribe manner to follow it and they also everything for 21(3) is completely liberated from the word go. 21(2) is a liberation from the prescribed procedure. 21(3) में prescribed procedure anyway. There is no place for prescribed procedure. Understanding beyond. Understanding outside.
Read 21 with Rule 25. Section 21 with Rule 25.
Yes, first I'll place it.
And address the words prescribed in subsection 1, subsection 2, and the absence of the word prescribed in subsection.
Certainly, 21.3 is wider than 2,
Please
but I will deal with
think about
21.2.
how would you interpret this statutory departure of the word prescribed? Prescribed is defined as per rules,
Correct.
right?
Absolutely.
Now, if you, the only way.
So therefore, this is an empowerment to deviate.
All right.
That's my humble submission, that this is unless otherwise ought not to be limited to the time period. It is, in the very beginning, it has been inserted. Also, Lord, see, 3 starts by saying notwithstanding anything in 2. It is independent of what is in 2. So it is not that from 2 something will not, the moment we deviate, it goes to 3. 3 is an independent, different, distinct power.
That is why I put the question to you. Is the quality of inquiry for revision same when it is done under subsection 2 and subsection
The
3?
difference will be, in my humble submission, this, that when we are deviating under 2, then we have a set of prescribed rules before us and we are deviating from that. Whereas 3 says, as it may think fit, and it overrides 2 completely.
So
therefore, under
no
3,
deviation, if any, from rules, that is the prescribed rules,
under 3,
is more eloquent in 3 than in 2.
no problem.
We are not disputing the fact that there is a residual jurisdiction of purported deviation from rules. At least the statute does not put a injunction on the Election Commission to follow the rules when it speaks of in such manner as it deems fit and proper.
Yes.
Whereas when you do it either under 2 or under 1, the statute puts an embargo to follow the rules, which is the prescribed manners.
Your Lordship, since your Lordship will have the plenary power under 324 of an election commission constituted under the Constitution, ordinarily, my Lord, your Lordship will construe these expressions in a wide manner, my Lords.
That is true.
Because, my Lord, elections and in preparation of electoral roll, so many things come up, circumstances spring up, which have to be dealt with, and that's the idea, my Lords. Now, let me take your Lordship's point to how these rules, this section emerged in the
Mr.
form
Dwivedi.
it is now today.
Mr. Dwivedi, assuming that we accept the way you are interpreting this non-obstante clause in 3, subsection 3, the question remains that ultimately there is a special intensive revision of the voter list under subsection 3. The revision of voter list can lead to some civil consequences against a person who is already a registered voter, right? The manner will be as you may deem it appropriate to prescribe. So therefore, when an action is likely to have impact on the civil rights of people, why should we not expect from you that the procedure which you will ultimately contemplate and follow will not be not less than transparent as under subsection 2?
No, so I have conceded in the beginning, my Lord, that I have to stand the test of Article 14, reasonable, just and fair, transparency, ease of voter. These and keeping in mind 326. Because nobody can deviate from 326, I cannot deviate from 326. So these are the 5 broad parameters. So it is not my submission that we can just frame any kind of SIR. I will have to satisfy your lordships, having explained this in the manner I understand. I will have to explain it, satisfy your lordship that it is just and fair.
The last one, 66. 23 was there in 56. 21. This one. Doesn't need to be. No. This allows you to do it at all. This allows you not to do it. This allows you to do it. Is that right? It allows you not to do it. Simply allows you to do it at all. Unless otherwise you shall. You're right. I'm sure of the what you do. Okay. It's not 100%. $66 million to a government II. 56 that proviso was already there, so it is not with respect to the timeline. Amendment which was made unless otherwise directed comes in 66. 21-3 was also very sense. दूसरी चीज यहाँ ये जो प्रिस्क्राइब अमेंडमेंट है ये यहाँ पे रिलैक्स हम कर सकते हैं यहाँ पे तो वो शुरू ही नहीं होता दूसरी चीज ये प्रिपरेशन रिवीजन है ये आ गया प्रिपरेशन पहले वाला ये रिवीजन है ये स्पेशल है so these are two distinct categories of revision in 2 and 3 which are totally independent of each other.
In any way, Lords, with the query of your Lordships, Lord, that how far you can deviate.
Correct.
That I have to deal with, Lords. Definitely, whether your Lordship comprehends, Lord, the power under 2 also or not.
No power can be untrammeled, no power can be completely unregulated.
Absolutely, Lord.
While the power should not be diluted, but it should not be left an
Absolutely.
unruly horse.
Absolutely.
It should be regulated properly.
Absolutely.
Even the constitution debates say that it's no imperio imperium.
Now, Lord, your Lordships have delivered so many judgments on this, Lord.
No
lawyer can go to that extent of saying that we can do whatever we want. That is discorco. So, but as my lords have, I'm grateful, my lord, that subsection 3, the purpose of referring to 2, the power of deviation, 2 has a limited power of deviation.
Your notification also says that they have exercised power under subsection 3.
So I'm not moving away from that, my lord.
No, we are just getting a clarification from you. It is not subsection 2, it is subsection 3.
Although, my lords, as the lordships have been held, my lord, pleased to hold that.
No, wrong citation,
wrong,
all those.
That I'm saying, my lord, before a lordship, my submission is that I have my SIR is sustainable under Article 324, read with 21.3.
21, that is it.
And I was referring to 21.2 to demonstrate this, that under 21.2, we have a set of rules in front.
We find it a bit. Yes, it's a way of looking at it, that's all.
That's a very.
We have, yes, you have given a new insight to that otherwise. But generally, we would read it as with regard to the time at which you are invoking powers under subsection.
That would be limiting the scope of.
All that we can say is your argument is attractive, but ultimately, how much it is.
It is safer, let us say, speaking in your favor, it is safer to reposit the power in subsection 3 than subsection 2. It gives you, Mr. Dwivedi, it gives your client more elbow space.
No, I'm saying something. With respect, Feroz, I'm saying something else. I'm saying that the scope under 21.2 is limited.
Right.
Under 21.3, it is wider.
Wider, but not unlimited.
Of course, it can't be unlimited. So 21.3, it is much wider. That's the endeavor.
That is your submission. You get it.
Now, I would like to place before your lordships 3 enactments by which these 21 has been amended. How it came to take the shape it has now.
21 was amended way back in 1966.
Kindly first have the original one at page 118.
66 rather. Oh, 66.
56 में sir, पूरा slide change किया.
At page 127 is section 21 to 25. No, this is amended.
66, 118.
Written
I'm
submission.
sorry, at page 118.
It was mostly 23, 24, 25 sections. Then it was entirely changed to 21, 22, 23.
Please tell the page number again.
118.
Of your
Of the written submission.
submission.
Written submission itself, I have next.
God, yeah. Annual preparation and power.
Now, see, section 23, 24, 25 were separately.
Sir, ये written
Each page.
the body. So, underneath.
Yes, good.
Those are the only sections in the points.
Kindly have section 23.
Yeah.
That page numbering is slightly smudged, my lord.
With the border.
Just above the border it is.
It's smudging.
Yes.
Section 23, the electoral roll for each constituency shall be prepared by the electoral registration officer, who shall be such officer of government or of a local authority as the election commission may, in consultation with the government of state in which the constituency is situated, designate or nominate in this behalf. An electoral registration officer may, subject to any prescribed restrictions, employ such person. Then annual preparation. The electoral roll for each constituency shall be prepared every year in the prescribed manner by reference to the qualifying date. 24. Subject to the other provisions of this Act, the electoral roll for any constituency first prepared under this Act shall come into force immediately upon its final publication in accordance with the rules made under this Act and shall remain in force until the 30th of September 1952, and every electoral roll subsequently prepared under this Act shall come into force on 1st October next after the qualifying date by reference to which that roll is prepared and shall remain in force until 30th September. So it was annual. If for any reason the electoral roll for any constituency or part of a constituency is in any year not finally published in the prescribed manner before so and so, then until the day on which it's so published, electoral roll in force immediately before the first day. So there is no provision like 21(3) or 21(2) which says unless otherwise. It was strictly, that was the first. Now
MC 25.
25 is revision.
That is the
Notwithstanding
precursor
anything.
of 21.3.
Yes. No. And
21.2.
notwithstanding anything contained in section 23 and 24, the Election Commission may at any time for reasons to be recorded in writing direct the revision in the prescribed manner of the electoral roll or part of constituency, and when a listing
It's 22 to 23 is changed in 56. Mm. 157 question.
ठीक है देख रहे हैं भाई.
There was no power to deviate originally.
Next वाला कहाँ है? 66.
127 is 56. This is 50, then 56 amendments, then 66. Twenty-one से start हो रहा. 27. Section 15 is a substitution rule. Section 15. The next batch of amendments come. And in this, 2 still has that proviso which allows them to not do it. It's not related to timeline. 56 में रिविजन की पावर 56 में ही हर in the same manner as it used to be. 56 amendment was 127. Right, it's in the transmission. So that predates section 2 as it stands today. Because that came in by 66 amendment.
Okay. I've seen it. Yeah. And with the ways of something. Media 127. The 1950s or something. 66. There's a new section. You know, if they would substitute the entire 24 to 21 to 24. Yeah. First of all. Yeah. 60. No, starts to take one. Means
But then 22.
direction release. Given to even say maybe. We have says. And for us, means as it is
66 वाला कहाँ?
66 is it? 137 what you said.
That's bad only the wind between 66.
9. This brings in section 2 as it stands to.
This is 66. And there is a yes, 9. So here we have the 9. Expand over there. And just can compare.
So, beloveds, I was placing at 118. You'll also see that section 25 does not contain that expression unless otherwise prescribed.
Prescribed.
Nor does it have section 21.3. Both are missing here. Now kindly have 127.
So yearly, first it started was yearly.
That's because of the new, just first election was to be held.
No. That was in our estimation, the population was moving. People were moving.
And
into
refugees
it.
were
Yes.
refugees were coming.
That is the vision of the parliament,
Yes.
that we need to yearly review because of Article 7. People coming into India who have origins in India. So you have to include them.
But they also said because not in 1951, because they knew it. Yes. That
That
1951 means
Nehru Liaquat agreement was of 1950.
people will keep on settling.
They will require 2-3 years to settle down.
Settled down the
That is why
refugees.
yearly.
Then there was also a provision that those who have gone to Pakistan, they can come back
Correct.
before a particular date, 31st December 1950. So,
There were portions in India which was in Pakistan on the 15th of August.
yes.
One of the districts in the state of West Bengal had the Pakistan flag flying on the 15th of August. Murshidabad. And then one district was put to East Pakistan, Khulna, and Murshidabad came to West Bengal. So you see, so much of flux was taking place.
And
at that.
Sylhet went to East
Select from Assam.
Assam.
Yes.
Now, then at page 127, this is the 1956 amendment.
My mother is from East Pakistan.
Mandates the opinion. Others in the last Yes, but we can just CB 20. That's what
Now kindly have page 127. This is of the written submission.
This is amendment.
This is the 1956 amendment. That is after the first election and before the second election. Section 15 at the bottom of the page 127.
Of the amending act.
The 21 to 25 were substituted. The electoral roll for each constituency shall be prepared in the prescribed manner by reference to the qualifying date and shall come into force immediately upon its final publication in accordance with rules made under this Act. The said electoral roll shall thereafter be revised in every subsequent year in the prescribed manner by reference to the qualifying date. Now, still that expression is not there unless otherwise. Now, next page. The proviso had been already inserted, which is now still there. Provided that if for any reason the electoral roll is not revised in any year, the validity or continued operation of the electoral roll shall not thereby be affected. Notwithstanding anything contained, now 21.3 comes in. But 21.2 still doesn't have that unless otherwise. Now this is very important. Notwithstanding anything contained in subsection 2, the Election Commission may at any time, for reasons to be recorded, direct a special revision of electoral roll for any constituency or part of a constituency in such a manner as it may think fit, provided that subject to the other provision of the Act, electoral roll for the constituency as in force at the time of the issue of such direction shall continue to be in force until the completion of a special revision. So now 21.3 as it now stands was inserted in 56, but in 21.2 that expression is still not there.
Because of that, we could come to.
So in 1956, even though subsection 21.2 did not have that expression, unless otherwise, still 21.3 was available in the form as it exists. Now kindly have a look at page 137. In section 21 of 1950 Act, for subsection 2, the following subsections shall be substituted. The said electoral roll A shall, unless otherwise directed by the Election Commission for reasons to be recorded in writing, be revised in the prescribed manner by reference to. Now, therefore, my lord, there are two independent powers in different situations, and unless otherwise prescribed, which is now being inserted despite 21.3 being in existence, therefore has to be given, my lord, its significance. Subject, of course, to Article 14, transparency, etc. As I look at it, my lord, 21.2, we have a set of rules before that, and the deviation is contemplated, so it has to be in the context of rule. Now, Rule 25 also, if your lordship has once again, expressly limits itself to 21.2. It has no reference to 21.3. So my submission is that deviation authority under 21.3 is wider than the deviation authority under 21.2.
Section 1.
Hmm.
21.3 में special revision है. ये 25 में तो revised intensively है ना. ये revision है 21.3 पर. Intensive है. It does not special revision.
Correct.
25.2 is not special revision. It is a revision under 21.2.
Now kindly have Rule 25.1. The roll for every constituency shall be revised under subsection 2 of 21. Either intensively or summarily or partly intensively, partly summarily, as the Election Commission may direct.
This intensive is not special.
That's all right. Then where the roll or any part thereof is to be revised intensively in any year, it shall be prepared afresh, and rules 4 to 23 shall apply in relation to revision as they apply in relation to the first preparation of roll. When the roll or part of thereof is to be revised summarily in any year, in the registration of officer shall cause to be prepared a list of amendments to the relevant parts of the roll on the basis of information shared. Now, even 4, where at any time between publication of draft revised roll under subrule 2 or of roll and list of amendments under subrule 3.
This is not really relevant.
So I am only saying
What is relevant are
1 and 2.
1 and 2.
Now both are applicable to 21.2.
The thing is, 1 specifically says subsection 2.
Yes.
2, whether it should be read read to include all intensive revision or in relation to subsection
It
2?
has, with respect, my lord, it has to be
You will
confined.
say that this will be also restricted to under
The
subsection.
reason is that 21(1) says either summary or revision or partly this or
Yes.
partly that. Therefore, 2 cannot go much beyond that, my lord.
So a special revision is not governed by 25(1) or
Full
25(2).
That's my humble submission. It doesn't.
The revision intensively is not equal to special revision.
Hmm.
The problem is your definition. You introduce the word intensive.
Now, now let me assume against myself, my lords, that 21(2) stands in isolation and is something covering some extra ground. It cannot take away the discretion which is vested under the Act. 21(3) rule cannot go beyond the Act, my lords. So 21(3), if it is saying that as it thinks fit, whatever be the other limitations constitutional on as it thinks fit, what this rule 25, no rule making power, my lord, can be going against the statute. So section 28, which confers the rule making power, cannot authorize a departure from, it cannot curtail the ambit. It cannot.
It can regulate.
It-
It cannot curtail, but
Curtail.
it may regulate.
Yes. But here it will be a curtailment if 25(2) is read as applicable to 21(3), because that thing as it
that
thinks
we
fit, and this is saying
That we follow, that if we read that the rules 4 to 24 become a stranglehold on
Yes.
the election commission in respect of a special revision, then we are rewriting the word as it made into.
then 21(3) is redundant, then 21(2) is sufficient.
This is why we were trying to indicate to you that
Yes.
is the difference between a revision under 21(2)
That's right.
and 21(3).
Yeah.
And in that perspective, the wider interpretation as it may deem, wider interpretation of as the election commission for reasons to be recorded in writing need not be given that liberal interpretation. It can be restricted to the scope of subsection 2 because there is a much wider scope already vested in subsection.
That's right. But not, despite the fact in 1956, 21(3) had been brought in, the Parliament felt it necessary to amend 21(2) and also insert there that you.
Sir, why you will see is because clause B is introduced.
Lord, I'm sorry.
Clause B is introduced that it can be done in any year, apart from the election year.
With great deference,
For that, it was every year.
with great deference, my lords, kindly have a look at once again, Lord, for my
Yes, sir.
sake, my lords, 21(2). 21(2), unless otherwise directed, is inbuilt in clause A. It has no application to B. It is inbuilt in clause A, not in the main part. Said electoral roll A, unless otherwise directed. So unless otherwise is inbuilt in A itself, it has no application to B. B says it has to be in the prescribed manner. However, my lord, we don't need to go that far, as the lordships have been pleased to observe. 21(3) is a clear provision. 25 is, in my humble submission, confined to both sub-rule 1 and 2 to 21(2). And it cannot have any application to 21(3), and it does not purport in terms to apply to 21(3). कहाँ पर? तो दूसरे वाले लिस्ट में now before I switch below that, there is one more case, that is Indrajit Barua, which was strongly relied upon. which in my humble submission, Lord, is completely supporting our case rather than theirs. That is 1985. Okay, so किस वॉल्यूम में है?
You want to read the first one or the
हाँ,
second one?
first one.
Yeah.
वॉल्यूम 5A आपने निकाल लिया है? अच्छा ठीक है, दे दीजिए 1985 1 SCC पेज 21.
Page 19.
119 or page 1.
It's all right, you can refer only. Huh?
In the market of
Acha, Your Lordship, my learned friend says Your Lordship must have marked that page in the volume.
Page 19
5A.
in our volume, I think we had referred to it.
Roman 5A.
5A.
So I think that's
This is a reverse case where the petition had been filed that why are you holding the election in 1983 based on an electoral roll of finalized in 1979 without revising it as mandated by 21(2)(a). May I place from paragraph 1, Lord?
Yes.
Transferred writ petitions so challenge the validity of elections to the Assam Legislative Assembly held in February 1983. Principal ground on which the validity of election has been challenged is that electoral rolls were not revised before the elections in contravention of Section 21, subsection 2A of the Representation of People Act, and the elections were held on the basis of electoral rolls of 1979. Now, it is undoubtedly true that electoral rolls were not revised before the impugned elections were held, but the Election Commission dispensed with the revision of the electoral rolls by an order dated January 7, 1983, made under the opening part of Section 21, subsection 2. So, therefore, otherwise prescribed, my lords, this order was under 21(2), and ultimately this court has upheld this. Hence, the impugned elections cannot be challenged. This order has not been challenged. Hence, the impugned elections cannot be challenged on the ground that if they were held on the basis of electoral rolls of 1979 without revision. Petitioners also attacked the validity of the rolls on the ground that the Election Commission, held by the press note dated September 18, 1979, erroneously directed the electoral authorities in charge of revision of electoral rolls not to delete the names of any person from the electoral rolls on the ground of lack of qualification of citizenship, since the question of citizenship was not one which could be decided by the electoral authorities, and the electoral rolls of 1979 were therefore invalid, and the impugned elections This establishes 21 Kuka independent months. थोड़ा बहुत स्किल करेगा वेडनेसडे को. Right. Then paragraph 3.
Yes.
We are of the view that once the final electoral rolls are published and elections are held on the basis of such electoral roll, it is not open to anyone to challenge the election from any constituency or constituencies on the ground that electoral rolls were defective. That is not a ground available for challenge an election under Section 100 of the Representation of People Act. The finality of the electoral rolls cannot be assailed in a proceeding challenging the validity of election held on the basis of such electoral rolls, void so and so. Then para 4 is important. We may also point out that in our opinion, electoral rolls of 1979 cannot be condemned as invalid, even if they are examining. The counter affidavits of Sri Ganeshan, Secretary to the Election Commission, and Ashok Kumar Arora so and so clearly show that the procedure prescribed by the Representation of People Act for revision of electoral rolls was followed. The press note is September 18, 1979, on which considerable reliance was placed on behalf of petitioners, must be read along with the correspondence exchanged between the Chief Electoral Officer Assam and the Secretary of Election Commission prior to the issue of press note. And if all these documents are read as a whole, it is clear that no instructions were issued by the Election Commission to the Chief Electoral Officer not to decide the question of citizenship. If any objection to a particular entry in the draft electoral rolls was raised on the ground of lack of qualification of citizenship. All that the Election Commission directed the Chief Electoral Officer to do so was to proceed on the basis that those whose names are already included in the previous electoral rolls, and we will point out that the electoral roll on the basis of which the elections of the Assam were held were not at any time challenged by any of the petitioners should be a prima facie regarded as satisfying the qualification of citizens, and if any specific objection to inclusion of any particular person on the ground of lack of qualification of citizenship was raised, it should be decided by appropriate electoral authorities, and the burden of showing that such was not a citizen would be on the objector. We are informed that the affidavits also go to show that in fact a large number of objections based on the ground of lack of qualifications were disposed of by the appropriate electoral authorities after the publication of the draft rolls. Then they reiterate that once again that even if electoral rolls of 1979 were invalid, that would not affect the validity of the impugned elections. However, subsequently, a statement was recorded that in future, when situations are better, circumstances are. I'll try to conclude tomorrow, but it's possible that there might be a little spill.
We will
I
conclude.
will make all my efforts.
Now that the real points are zeroed down, we can.
I will have to deal with that manifest arbitration is equal to full due process of the American kind, which Mr. Singhvi raised forcefully.
Manifest arbitrariness is also now well defined expression. You don't require to spend so much energy on it.
I will spend a little time only to show that American due process is rejected by Dr. Ambedkar and 9 judges bench of this court, and even my Lord Justice, the Chief Justice's judgment, my Lord. Your Lordships have, without saying so, my Lord, added something more to Justice Nariman's observation in 1 or 2 cases, my Lord. He tried to say that because of reasonable, just, and fair, my Lord, it is now the American due process. I had specifically argued that in that Aadhaar matter, Puttaswamy's case, before 9 judges, and that was not accepted. No. So that will take us very short time. I will basically go by the formulation which my Lords has laid down in section 6A.
If you want to continue for another 15-20 minutes today, we can continue, and then tomorrow we
I can complete this Barwa's case. That's all.
let us, this part you can finish.
Even then, there might be
Because we got late in lunch, where sometime I have to deal with administrative files, and so I get late in sitting.
strain. My Lord. It will
That
in any
much-
case not.
No, it should be fair to you in allocation of time. You said. Rightly in the context of taking a ground in an election petition, that the voter list is erroneously prepared, or the election commission committed an error.
They wanted to rely on those observations where the court says that in this case there was objections raised. So if it was, nobody said, no directions were issued that don't decide citizenship, and many objections were raised which were decided.
Argument is Borua is not an authority for the proposition.
It's not an SIR case.
Election Commission does not have own powers
Yes.
to examine the issue of citizenship.
That's right.
That's it.
In fact, at page 27, I'll just read out, but my Lordship will not open it. It is entirely for the Election Commission to decide in the exercise of its discretion whether it should carry out such revisions suo motu under Rule 25 of the Electoral Rules 1960. We cannot direct the Election Commission to carry out such a revision, which under the law it may do so on its own. We can't, it's up to the Commission. And then it goes on to say that when the draft electoral rolls were ready as a result of such revision carried out by the Commission, it will be open to anyone whose name is not included. Now, this was a case under 21(2). We are here concerned with an SIR under 3, which SIR can resort to verification. Under 21(2, it's a summary kind of revision, maybe intensive, but it remains summary. Or it is partly summary, partly intensive, depending upon what it is. It's not a revision under 3. It's not an SIR. And 1979, Assam, that list was an SIR list which was followed. So this, based on objection,
So we didn't do it.
now, my lords, if I may come to the statutory provisions, the next part of the submission. Kindly have the Representation of People Act. Kindly have the Representation of People Act.
1950.
1950, I'm sorry. Yes.
Yes.
So now my endeavor is to show that Election Commission is not, the doors of revision in a special manner are not foreclosed, rather expressly permitted. Kindly have section 15. For every constituency, there shall be an electoral roll which shall be prepared in accordance with the provisions of this Act under the superintendent's direction and control of the Election Commission. So 324 is expressly preserved by section 15. Would you like to tell? Now, this provision has been just like this from the very beginning, 1952, when it was made. Now, then have section 21. Electoral roll for each constituency shall be prepared in the prescribed manner by reference to the qualifying date and shall come into force immediately upon its final publication in accordance with the rules made under this Act. Now, this is the original provision. Now, kindly have two. The said electoral roll shall, unless otherwise directed by the Election Commission for reasons to be recorded in writing, be revised in the prescribed manner by reference to the qualifying date. If I may request the Lordships to pause here. Even subsection 2 says, unless otherwise directed by the Election Commission. I am emphasizing this expression. Kindly mark this, Lord. Yes, right. And this revision is the regarding the electoral roll made under subsection 1.
So there is a power vested in the Election Commission, even over and above what the legislature has infused in 21(2).
Yes, 21(2), 21(3), both are provisions of Parliament, and the Parliament envisages that the Election Commission can otherwise prescribe. And this otherwise prescribed is in the context of revision of the roll prepared under subsection 1. It says the said electoral roll shall, unless otherwise directed by the Election Commission, for reasons to be recorded in writing, be revised in the prescribed manner by reference to qualifying dates. So if I don't revise it, then the rules operate. But if I revise it, if I direct otherwise, then that change, the rules will operate subject to the change.
And power overriding the rules or whatever that can be enacted by the legislature.
That's it. The rules will come, are made by central government under this in consultation with the commission. So the rules which will be made, they can be deviated from. What will be the manner, what will be the extent will depend upon the circumstances prevalent in the state. 21 is a parliamentary dispensation, nothing to do with central government. Central government will come in when the rules are made. And it says before each general election to the House of People, 2 before each by-election House of People or the Legislative Assembly, 2 before each by-election. So the revision must take place before each state assembly election. Ordinarily, it will be in accordance with rules, but the Election Commission of India can, taking note of the circumstances prevalent, direct otherwise. Now, B further makes it clear that this has nothing to do with the time. It has to do with the content of that is the rules according to which revision election is to be held, roll is to be prepared. B says, shall be revised in any year in the prescribed manner by reference to the qualifying date, if such revision has been directed. So if it is being held otherwise before the elections, then it is to be done in the prescribed manner. The discretion is not there. Provided that if the electoral roll is not revised, the validity of the old electoral roll continues. That's not affected. Now, 3. Notwithstanding anything contained in subsection 2, the Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency or part of a constituency. Here again, subsection 3 says that the Election Commission may, for reasons to be recorded, direct a special revision in such manner as it may think fit. This expression. The net result of the expression, unless otherwise directed in 2A, and as it may think fit in 3, so the Parliament has not closed the door for Election Commission, but rather preserved its powers and functions under Article 324 for the purposes of providing a methodology of preparing roll, which is otherwise than the rules, otherwise than as prescribed in the rules. So the position, my lord, is clear that this case is unlike Joe's, where the rule said you will do it by ballot paper, and this court interpreted to mean ballot paper alone. Therefore, Election Commission could not deviate. But here our section 21, 2 and 3 both were together expressly preserve the power of the Election Commission of India to deviate. So 324 is not shut out, not foreclosed.
Parliament has notified, or the legislature has notified a set of rules. Say, for example, for the revision of electoral rules, 21(2) enables you to go even beyond those rules, because those rules are subject to your power. You have an overriding power over those rules. Then, assuming that in exercise of that overriding power, you notify something which is over and above those statutory rules, then subsection 3 absolve you even to follow that your own notified criteria, rules or regulations of 21(2) when you undertake special revision under subsection 3.
Yes. So both 2 and 3, 2 says before every election, 3 says even otherwise when you are directing, if there is no election, yet we can direct not a special revision. 2 is before every election. Now, for example, in many states, there is no election happening. It's only in 5 states where there are elections in this particular year. So where there is no election in UP 2027, then 21(3) comes in. At any time, we can direct special revision. Both are akin, identical, with same kind of power. Of course, we have to be fair, just and reasonable. That mandate of Article 14, fair, just and reasonable and transparent.
Are you saying that subsection 2 of subsection 21 and subsection 3 of section 21 have the same nature of inquiry or preparation of
The
those?
same width.
Is it so?
That's my humble submission was. Because unless otherwise directed, revised in the prescribed.
Just try and it's the word hand.
Hmm.
91 is completely liberated. There is no prescribed manner. Prescribed manner का जिक्र ही नहीं है 21 section. यहाँ prescribed manner reason से बहुत कम है. Start में ही नहीं है. जब यहाँ start is understanding into do my prescribed manner to forward and they also everything for 21 is completely liberated from the word go. 21 is a liberation from the prescribed procedure. 21 female prescribed procedure anyway. There is no place for prescribed procedure. Understanding to be beyond. Understanding after.
Yes, at any point.
What is special?